Wasn't rolling.
No, that's the first break I've caught for a while. All right, thank you very much.
Judge, before we bring the witness in, can we address the issue that was raised when
Sure.
the witness on the stand regarding the disclosure of the reports?
Right.
So, as the court knows, Supreme Court Rule 412 requires that any reports or statements of experts made in conjunction with a particular case should be turned over. The witness has now testified that she may be sent 2 or 3 reports to the state. Maybe 2 or 3 reports were sent to the state. We received 1 report in discovery on the state's 6th supplemental answer to discovery filed on December 17th of 2020, pages 3132 through 3196, date stamp numbers. And a supplement on the 10th supplemental answer to discovery, we received the invoice that Ms. Lee was asking her about, which was base stamps 3357 through 3359. The Supreme Court rule does not say only final reports shall be tendered. It's any reports of experts. And until she got on the stand and admitted that she had tendered 2 or 3, maybe 2 or 3, we had no knowledge that she had in fact tendered draft reports to the state. We're asking that those be disclosed before we continue with the cross-examination of her, as is required by Supreme Court Rule 4.
State.
Judge, I'm going to respond to this one. Supreme Court Rule 412 has been completely complied with. And if you take a look at the expert report that Ms. Ruzicka prepared in this case, that counsel has, that they've had for a long time, and they've had actually this invoice, I believe they sent for close to 2 years, yet doesn't ever come up ever. It is a Q&A, question of reports. Ms. Ruzicka said that she asked if there was things that were missing. So it may have been a question. She said there was 1 final report and she asked questions. There is nothing that has been withheld from these attorneys, and they certainly never raised it, to ask this mid-trial when Ms. Ruzicka has testified in prior proceedings, when they had the ability to file any motions. We've been working on stipulations forever. In fact, I believe it was last month we finally found out they weren't calling any expert in this case. I think it's really unfair and an outrageous allegation at this point.
So, defense, how long have you had the invoice that would appear to suggest this?
We have had the invoice since August of 2021, but
Okay.
we never had the opportunity to question her about it. The invoice simply states requested revisions. Doesn't say what those revisions were, so until we had the opportunity to actually question her about what those revisions are, if it in fact was a written report or if it was just something she was keeping to herself and drafting, we had no ability to know what that actually meant. And it certainly wasn't, even though we had a hearing on this case where she testified, that was specific to the motion in limine. It wasn't just an opportunity to depose her and ask her unlimited questions at that point in time. It was simply, the report itself says requested report revisions. So that could mean a lot of things. Until she said that the requested report revisions meant that she had sent them drafts and then got back and made requested revisions, we had no idea that's actually what it was.
So, number one, have you ever attempted to ask her that question? You said we had no ability to ask her this. Did you ever call her up and ask her?
She's the state's retained expert, Judge. I don't believe that we can communicate with the state's retained expert.
That's not true.
And I believe retained experts are within the control of their...
No, but there is no principle of discovery that says you cannot contact a state's expert, retained expert. That's number one, and that is clearly true. Number two, did you ask them? Did you ask the state? Well, wait a minute, there's talk about a revision here. State, what about this? Do you have other revisions?
With all due respect, the state has tendered 20 discovery answers in this case. They certainly have tendered multiple things over and over again. It's their obligation. It's not on our obligation to ask them what their expert...
All right, when I ask a direct question, I want a direct answer.
No, we didn't ask them if they had multiple revisions of the same report.
Okay, and by the way, talking about depositions, this isn't a deposition either.
Correct.
All right? You could have asked about this before. Now, number one, if they do exist, I'm going to order it. I'm not going to hold her testimony in advance. If you want to call it later, fine. You were on notice about this before. There's absolutely nothing that prohibited you from asking her before about this. There is nothing that says you cannot contact a state's retained expert. Frankly, in all my years doing this, I've never even heard an attorney say that to me before. And it's not what the law is. So you should have asked. So we're not going to stop in the middle, well, not in the middle of her testimony. She's been on the stand for over 7 hours at this point. So state if you have revisions, I'm going to order that you give the revisions. It doesn't mean they're not controlled by the discovery rules. And if for some reason there's something substantive in there, then you can call her as a witness later on in your case. So your request to have her testimony held in abeyance is denied. And the court does find that there was an ability to ascertain this long ago, 2 years ago, starting 2 years ago. All right, bring her back in, please. You can get on the witness stand, ma'am. Go ahead.
Thank you. Ms. Rosica, you will recall I asked some questions about Mr. Acosta's case assignments in December of 2018 and January of 2019, correct?
You did.
You said that you had no memory of sending an email about the case assignments, correct?
I don't.
Do you know who David Nika is, N-I-K-A?
No, I don't know who that is.
On Wednesday, July 12th, 2019 at 5:36 p.m., didn't you send an email to David Nika at david.nika@illinois.gov? Hi, David, can you pull the following information for me? Carlos Acosta from Woodstock, assigned investigative caseload, including report dates, case names, and SCR numbers from December 1st, 2018 through May 1st, 2019.
I have no memory of sending
I
that.
object at this point to impeachment by a collateral matter.
Response.
This doesn't go to impeachment, Judge. It goes to the substantive evidence that she has.
So you're, go ahead.
I apologize, Judge. I was just going to say, if it goes to the substantive information that's contained in that email, my objection would be hearsay.
All right, so the objection's overruled.
Go ahead and answer.
Yes.
I don't know who David Nika is.
Did you send that email on Wednesday, June 12th, 2019 at 5:36 p.m.?
I would have no idea if I did, especially if I don't even know who that gentleman is.
Is your memory exhausted as to your email exchange in June of 2019 about Mr. Carlos Acosta's caseload?
Yes, I would have no idea.
Would a copy of the email exchange refresh your recollection about that exchange?
It might.
Judge, can I approach the
You may.
witness? I'm showing you what's been marked for identification as Acosta Defendants Exhibit 1.
Okay.
Can you take a look at that document?
Oh. Okay.
Do you see at the bottom of page 1, the email I just read to you from Wednesday, June 12, 2019?
Okay. Oh,
In
wait.
reviewing the exhibit, does it appear that there is a response to you and you forwarding the information to someone else?
I did. I sent it to whoever this gentleman, David, is, who I have no memory of.
Does the Acosta Defendants Exhibit 1 refresh your recollection about your June 2019 email exchange about Mr. Acosta's caseload?
It's not June 19th.
June 2019.
Oh, I'm sorry. I thought you were referring to the date.
Does Acosta Defendants Exhibit 1 refresh your recollection about your email exchange about Mr. Acosta's caseload in June 2019?
Oh, yes. But
You remember it now?
I have no memory of this, I'll be honest. I'm reading what you gave me, but I have no memory of this whatsoever.
So this has not refreshed your recollection?
No, I'm sorry, it really is not.
If you did engage in this email exchange in June of 2019, requesting Mr. Acosta's caseload, receiving it, and forwarding it to someone else, did you review the information that was sent to you? Do you remember?
I would have no memory of that. I'm sorry.
And as you sit here today as the former regional supervisor for the Northern Region at the time that AJ Freund died, you have no recollection of what the caseload was of Mr. Acosta in December of 2018 or January of 2019?
I don't have that data in front of me, no.
You don't have it in front of you. My question is more specific. You don't have any recollection of his caseload.
It's specific what its exact numbers were, no, I do not.
And you don't have any recollection of ever asking for it.
I don't remember this email, this is a long time ago. During the time that I was regional administrator, I wrote many emails, so.
And you don't have any recollection of what Mr. Acosta's caseload was at that time.
I don't.
How many times did you meet with Mr. Keneally or anyone at the state's attorney's office about your testimony at trial?
I believe twice. Well, no, one was via Zoom,
But
twice.
not just in person, any kind of meeting.
I would say twice, to my knowledge.
And how many times did you meet with Mr. Keneally or anyone in the state's attorney's office to review the state's demonstrative exhibit?
This, you mean
The
this?
demonstrative exhibit, the binder that Mr. Keneally went through with you yesterday.
Once in totality.
What does that mean, once in totality?
There were a few questions relative to certain parts that was in the second conversation, but not the whole thing.
So you addressed the demonstrative exhibit in both of the meetings that you had with the state?
To some level, yes.
Okay. And at no time in those meetings did you point out that the procedures that you were reviewing in the demonstrative exhibit were not the procedures in effect in December of 2018 and January of 2019?
What more specifically you're asking, I'm sorry.
When you were meeting with the state about the demonstrative exhibit, at no time did you point out to them that the procedures that appeared in that exhibit were newer versions of the procedures?
No, that's correct.
Judge, if I could have one moment.
Okay?
No further questions.
Do you want this back?
Judge, I'll come get it.
Okay, somebody come get it.
Okay.
I'm not going to, so.
Sorry. Oh.
Ma'am, the reason you are here testifying in this trial is to deliver, which you did yesterday, an opinion that blames Andrew Polovin and Carlos Acosta for contributing to AJ Freund's murder. Isn't that right?
I would not use the word blame. That's not what my
What word
goal
would
is.
you use?
My job here was to go through procedures, as having been certified as an expert witness, as to what procedures, policy procedures say to do. It's not about pointing blame.
Well, you were asked specifically by the state's attorney that if services were in place through this case, that AJ would not have been murdered and discovered in April of 2019. Did you not testify to that?
That he would not have been murdered and found? I don't believe I testified to that part of it.
Well, let me ask you again. Mr. Keneally asked you that specific question. You do not recall that question?
That if I felt that service had been offered, I thought it was, would the child still be alive? But maybe,
Okay, so you're acknowledging the fact that had services been in place through this C-sequence case, that AJ would have been alive in April
that is what I testified, that was my belief.
and not murdered.
Well, I don't believe I entertained the word murder.
Well, I'm asking you,
Oh.
are you saying that as well, or just the first thing?
I'm saying that I believe the child would have been alive.
Okay. Ultimately, you disagree and have testified that you disagree with the judgment call made by Acosta and Polovin, correct?
Yes, I would say I disagree with that.
So as you sat here in court yesterday, you basically questioned their judgment call and said they made the wrong call, right?
I don't believe those were my words, but
Well, if you don't, how would you say it?
sort of what I had just said, that I believe that the child could have been alive if other call had been made.
And he made the wrong call. That's what you're saying, isn't it?
Essentially, yes.
And that's what this job is, isn't it, Ms. Rosica? It's making judgment calls.
It is, that is what it is.
And not just one a day, not just one an hour, it's judgment call after judgment call after judgment call all day, every day that you're working. Isn't that right?
That's fair, yes.
In fact, Ms. Rosica, you were the regional administrator when the C sequence came in back in December of 2018, and you were also the regional administrator when A.J. Freund's body was found in April of 2019. Isn't that correct?
That's correct.
You were a supervisor of the northern region in which Andrew Polovin worked as a supervisor for DCFS. Isn't that right?
I was an administrator, yes.
You were the regional administrator, correct?
Correct.
You were the boss over the northern region. Fair to say?
Fair to say.
And underneath you was what would be called there's an administrator below that covered the Woodstock field office, correct?
Correct. The title was area administrator.
Area administrator. And who was the area administrator during this time frame?
Rhonda Lay.
Did you have any involvement in the investigation of this C sequence case?
Did I personally have any
Yes.
talk about? No.
Did you have that case, that C sequence case, and any kind of a list or any indicator that that was something that needed your attention or needed your eyes on?
No, it had not been brought to my attention.
Okay. Who would have brought that to your attention if it was in fact flagged?
Generally, it would be the supervisor. It could start at a worker level to a supervisor, but then the supervisor to the area administrator. If the area administrator wasn't available, then it would be either somebody, the assigned area administrator. It could be somebody standing in for them, or I was always available. But it would come from being brought to the attention.
So there's been testimony in this case about certain cases that are treated with a little more special attention based on certain circumstances, correct?
Correct.
And the age of the abused child is relevant, between 0 to 6 years old, correct?
Correct.
AJ was 5 years old, correct?
Correct.
As you testified, that there was a history with Joanne Cunningham, his father, Andrew Freund, other people prior to the C sequence that had occurred with DCFS involvement, correct?
That's correct.
And based on those particular circumstances, and it was a number 11, it was a bruise, a wound to the child, correct?
As well as the environmental.
Okay. So there was also 2 allegations of environmental neglect.
No, there were 2 allegations, one
Okay.
of each.
All right, so it was a number 11 and the 82, right?
Correct, correct.
Based on those circumstances, was that a case that should have been on a list, a special list?
Any case can be on, I'm not sure what you mean by special list, but any case could be brought to administration's attention.
So a case that we brought to the area administrator, would she create a certain list, a particular list that would indicate to her that these cases may need extra attention and I need to be watching?
Would she have created a list?
Did she have one?
I don't-
Created one?
I don't know.
Did one exist?
I don't know. There were routine reviews that were done, but I think that had to do with if the cases had, how do I want to say this? But not just like an A sequence report, if they had higher sequences, but I believe that those mandatory reviews predated this, not for sure. There was a printout that we would get during that time, that these cases had to be reviewed. One was young children, one was this. But I think those lists in those reviews predated this. I'm not positive.
Okay. Well, you testified yesterday, I believe, at some point on cross-examination that for all intents and purposes, this case doesn't really qualify as a serious case, correct?
At face value, yes.
At face value, correct?
Yes.
And we're not minimizing the fact that the child sustained some type of an injury.
Sure.
But in your experience, there's cases that are not only slightly worse, even more worse, but egregiously worse, correct?
Very true.
And those cases, again, are going to get more special attention. Is that fair to say?
Historically, yes.
And those cases then would be more of a focus of not only the investigator, but the supervisor, and then possibly the area administrator as well, to spend time working on those cases, correct?
Could be.
In your role as regional administrator, what, if anything, or relationship or contact do you have with the people that are actually on the ground, the CPS, the PSA?
In that role?
Yes.
What kind of contact? When I was in that role, I would come to the various field offices. That was sort of my job, the field offices that I oversaw. And so I would come to the field office and see the staff. And again, if there was necessary or if there were issues, a lot of my job was meet with community providers. And I mean that from state's attorneys to community, I'll just leave it loosely, community providers. And so in that capacity, I would meet with those people in those areas. Again, a lot of times with the supervisors or area administrator.
And I'm going to ask you this.
Okay.
You were the regional administrator when all this went on, when this happened.
Yes?
You do not hold yourself in any way or hold on to some type of responsibility or guilt in the fact that this happened on your watch, do you?
No, I don't. There are layers of responsibility. And again, as I said, if things were not brought up to my attention, and it could have been from the field, it could have been from a state's attorney, it could have been from a hospital, community, police, whatever, I would not be directly involved. Again, there was another layer in between.
Despite that particular connection, at least to the regional office, as overseeing that office, and then ultimately, which the Woodstock field office was underneath, nothing about that relationship affects your objectivity here? Do you feel like you're an objective expert witness?
Maybe you could rephrase, I'm not sure what you mean. Sorry.
Do you have any personal feelings based on your relationship to your employment, your job, and the connection between these investigators through the hierarchy being under your watch? Do you feel that you still remain your objectivity as an expert witness?
Yes. My job was not to consider personal relationships. My job was to ensure that people were doing what they were hired and assigned to do. It wasn't personal.
Okay. So let's speak to that. You, in fact, were the area administrator over the field office in which you first met Andrew Polovin as a investigator, correct?
No, I don't think that's correct. But go ahead and ask, if you would ask me again.
Okay. So you were the area administrator
Yeah. Okay.
and area administrator, so between 2010 and May of 2018, correct?
I was. But-
And during that time, was Andrew Polovin an investigator, or started working as an investigator under an office under your purview?
Yeah, I just want to clarify, the title was different then.
Okay, fine, go ahead.
But it was a child protection manager
Okay.
that turned into the area administrator. So I believe when I started there, is a child protection manager. Correct.
Okay, and if I told you that he began as an investigator in 2008 through 2013. That 2013 time would have crossed over as your area manager, area administrator over him, correct?
That's correct. I was over his, over him, well, his supervisor.
And in fact, in 2013, Andrew Polovin was promoted to a supervisor under which he worked under your area administrator, as an area administrator, correct?
Yes.
Okay.
Yes.
Do you recall that his promotion to supervisor?
I was in charge of that office at the time he was promoted. Yes, if that's what you're asking.
I am. And then, at some point around February of 2018 is when you were elevated to regional administrator, correct?
Correct.
Okay. So you spent years as the supervisor for Andrew Polovin, correct?
I've known Andy for a number of years, yes.
Okay. And in that position that you had over him, and including your position that you held at the time that all of this happened, are you still telling us that you've remained objective in giving your opinion?
Yes.
Do you think, based on your relationship to the Woodstock field office, your relationship, or knowing Andrew Polovin for a long period of time, that you are the best person to do this job, being an expert witness in this case in which he's charged with a crime?
Objection, Your Honor.
Sustained.
In making judgment calls, let me ask you this.
Sure.
What's the goal of DCFS?
Child
What's its
safety.
mandate?
Child safety. From an investigative end, primarily.
And in order to do that, what's the driving principle that motivates one to focus on child safety? What principles are used to get that done?
Principles?
Yes. Best interest of the child, is that
Yeah.
is that a motivating principle?
Yes, yes. I'm sorry. Thank you.
Focusing on the safety of the child in real time with the facts and discovering those facts and figuring out what's in the best interest, where that child should be and who that child should be with, things like that?
Yes.
Would you say that is really, in essence, just the mandate of this is what DCF is for, and this is how we get it done, right?
Basically, yes, at a very basic level. Yeah.
But there's also a principle through DCFS where there's a goal or a motivator to keep the children with their parents in the family household, correct?
That is the current focus of the department,
So,
or it was then.
okay. But at the time, that was also a focus, correct?
It was to try to maintain children at home.
Would you say that those two principles are conflicting?
They can at times.
Because what might be in the best interest of the child, if we're all looking at it and feeling the same way we do about it, is to rip that kid out of that family's clutches and get him away, right?
I don't know if I'd say rip them out of families' clutches
Well,
and give
all
them
right,
that way.
I shouldn't, let me rephrase it then. I'm sorry, I'm getting carried away. Is to removing the children from the home, or a child from the home, may be what we want to do, but we can't do it because there's a process that we need to go through, keeping in mind that a strong motivator is to maintain the family structure.
Fair.
And then, at some point, DCFS, if they place the children in a safe place, remove them from a situation that they've determined to be abusive or a risk of harm or present harm, then they get in there and then they deal with the parents, correct?
The child's in care, yeah.
Right.
And it's focused on working with the parents towards reunification.
Right. And working towards reunification means changing their behavior, changing their mindset, changing their focus, correct?
It could be, yes, or whatever else.
So you want to fix the parents so you can get the kids back home, right?
Sometimes you also need to fix the kid.
Of course, of
But,
course.
yes.
Of course, but once that kid is safe, the focus is then on, we're going to fix the parents and we're going to make it okay.
And again, not dismissing that sometimes it's the kid, too.
Now, you indicated that your review, in order to give your opinion, was of the reports, the paper, the C-sequence report, and that's what you looked at when you decided and ultimately came to your decision to give the opinion that you gave, correct?
Yes, I reviewed the C-sequence.
And then the P300s, correct?
Yep,
Which are the guidelines, we all,
yes.
the court understands what those are by now, so we're not talking about those at all. Other than the fact that it's 500 pages or so.
Fair to say.
Okay, and ultimately, let me ask you this. Again, going back to this fact, these are judgment calls, so it's important to get, according to you, you want to consider as much information as possible, correct?
Correct.
Because that's how we make good decisions, right?
Correct.
Okay. And you want to do that without encumbering the decision maker with more burdensome things, just like the conflict between protecting the child and keeping the family intact, correct? So that's a stressor on a decision maker, correct? That's a push and a pull. Would you agree?
You have to, you have to weigh both sides? Is that
Right.
sort of, yes.
So you want to make that decision or that choice as simple as possible, correct?
I don't know if I'd say as simple, as comprehensive as possible.
Well, the answer to the question will be indicate or not, yes or no. That's a simple answer to the question, right? You want to make that answer clear and simple, right?
Ultimately, that is the decision. It's one or the other.
Do you think the P300s, the 500 pages that are put upon a decision maker, helps them or hinders them?
That's really not for me to say. It's the department, it's guidelines.
Right. But I'm asking you your opinion.
Oh, my personal opinion?
Yeah.
There are sections of that that are more pertinent to certain things, such as we were talking about 300.50 is more relevant to the investigator, 300.70 is more to the supervisors. There are certain areas that are more relevant.
Okay. So as a reference, you're considering it more of a reference vehicle in that description, correct?
It's a reference, a guideline. It's something that's always available for you to refer back to,
Well-
if that's what you mean.
Well, you made it pretty clear here that those are guidelines, and they need to be followed,
Yes.
correct?
Correct.
You've used the term mandatory numerous times in describing what is in those procedures and what has to be done, correct?
Correct.
And when I say has to be done, when it says shall means mandatory, correct?
Yes.
Should means a suggestion.
Yes, it means, yeah.
Are there shoulds in there or just shalls?
I believe there shoulds as well.
Did you factor in any outside stressors, circumstances, experiences that the decision makers in this case, Mr. Polavin and Mr. Acosta, were going through at the time when determining whether or not their judgment call was the correct one?
Like personal stressors?
Work stressors.
Did I consider that?
Anything outside of the paper, like things like that. I'll give you an example.
Yeah.
Did you consider Carlos Acosta's caseload?
When,
When you determined that his judgment call, when you made that ultimate decision and then wrote it down and testified to it, and Mr. Polavin, did you incorporate their caseloads and what they were dealing with at that time when they were dealing with this C-sequence case?
no.
Did you deal with the realities of what it was like for workers on the ground to deal with the caseload, the cases, and how they went about doing their job. Did you consider any of that?
No, because the procedures are what they are.
So the procedures are what they are. But you would agree with me that those things, caseloads, overloaded cases, was there pressure to close cases?
No,
So the administration did not put pressure on the CPA or the PSA and the investigator to close cases?
the expectation was investigations would be closed within 60 days. But again, as I testified, you could extend it for cause. But it wasn't, the expectation was it was to be closed in 60 days. So if that was the pressure, that was the pressure.
I know that's what the procedures say, but I'm talking about real life. Did you factor into the fact that Polivan's caseload was obscene? Acosta's caseload was obscene. You did not consider that?
Sustained.
Okay.
Sustained.
Let me ask you this.
Uh-huh.
Was DCFS humming on all cylinders back then in 2018, 2019?
As an agency,
Yes.
I don't think it ever has.
Okay. And that's why there's been a consent decree in place for almost 20 years, right?
I would say yes.
And a big part of that consent decree is the fact that those caseloads that were placed upon the workers in Illinois in DCFS were out of control. And that affected the decision-making and the process of doing their jobs, correct?
I can't tell you the motivation and what was behind putting that consent decree in place, but it did affect all the caseloads and things like that. It's helped.
Okay, so you're saying that they mentioned or mandated some regulation on top of caseloads and things like that and said this is what it should look like, correct?
In the ideal world, yes.
So they dealt with it, correct?
Yeah.
Which would mean it was a problem that needed to be dealt with, correct?
I would assume, but again, I wasn't part of any of that.
The significance of dealing with those kind of things means there's a problem. Doesn't that make sense?
Or it could have been trying to prevent a problem.
And I'm going to ask one more time because I'm not 100% sure. But you're saying that DCFS administration did not put pressure on the workers to close cases to make sure their stats were right.
Objection has been answered.
Sustained.
You agree that in December of 2018, the Woodstock field office was understaffed to handle the caseload that they had, correct?
I know in December of 2018, Mr. Polivan's staff, or his team was fully staffed. That I do know. I couldn't tell you about the field office off the top of my head as a whole.
Okay. He had 7 investigators in 2018, correct?
That is correct.
And that was mandated also in the consent decree, 7, up to 7, but 7 was the threshold, right?
I believe so. I believe so. Again, I haven't looked at that consent decree in some years.
Okay. So you didn't consult, again, in your preparations to give this opinion, you did not consult the consent decree in order to give an opinion in this case, correct?
Yeah, I didn't review this consent decree.
Because it didn't, the reality of the situation didn't matter to you.
I don't think I would say that, but I just didn't do it.
Why wouldn't you?
Why wouldn't?
Why wouldn't you look at those kind of things? Don't you think that affects someone's decision-making and allows you a better perspective and to determine whether they were right or wrong?
What a consent decree, no, I wouldn't have reviewed that.
Or that it wasn't being complied with and they were overloaded? That didn't factor in there. You didn't care about that when you were making your determination.
I don't think the word care is quite right.
Well,
Did I factor into their caseloads and their numbers when I rendered an opinion? No, because again, procedures are standalone regardless of numbers and caseloads.
again, though, it wasn't just procedures weren't followed. you're saying should have been indicated, aren't you?
My personal opinion is yes, it should have been indicated.
Okay. So if I told you that in 2018, Mr. Polovin had 1,063 reports, would you have any reason to disagree with that number?
Judge, I'm going to object to that question.
Response?
Judge, if she knows, she knows. If she doesn't, she doesn't. I think it's a fair question.
I wouldn't know what.
Judge, I'm sorry.
Yeah, you have to wait for me to
Oh,
rule on
I'm
the
sorry.
objection.
I'm sorry.
The objection's overruled.
Are you aware that that was his number?
I'm not aware of that.
Are you aware of how much higher his caseload was than what was basically instructed in the consent decree to have?
No, because I don't know what his caseload number was.
You know that 750 cases a year was the limitation that the consent decree placed upon a supervisor, correct?
That number doesn't even ring a bell with me.
So you really have no recollection of the consent decree at all?
I do, but not specific numbers like that, 750? No. And again, though the consent decree, as I understood it, was a guide, too. It wasn't, there were exceptions all over the place. And again, I wasn't a part of any of that. That wasn't in my job.
Well, you were,
No,
you were a PSA during your tenure in DCFS, correct?
right.
And are you telling us that those numbers, the caseloads, weren't relevant to the job
No,
that you were
I'm
doing
saying
at that time?
I didn't have anything to do with formulating or having any part of that consent decree when it got put in place.
But once it was in place and it was there, they gave you a copy and you read it, right?
I'm sure I did back in the day, sure.
And it was important, wasn't it?
It was important, yes.
Are you familiar with what a blitz is?
Uh-huh.
What's a
Well,
blitz?
when I was there, I know what it was.
That's what I want to know.
Okay. It was something where typically it was done in areas where caseloads were getting, I'm going to use for lack of better, out of control. The numbers were very, very high. And I was part of one that was in Southern Illinois, so kind of quite a number of years ago. So what we did was to bring in, offer, because we're a union shop, so you offer to staff based on seniority, the opportunity to come and work. Typically, my experience was it was on a weekend. Can't tell you, but generally it was on a weekend. To come in and work cases that basically were sitting in hopes of moving them more towards closure, if that helps.
So how old were these cases that were lying around that needed a blitz?
Are you asking in the times the ones that I were involved with?
Sure, in your experience.
Oh, boy. When I did it in Southern Illinois, that had to be, gosh, could have been 20 years ago.
Judge, I'm going to object to relevance.
Response?
Judge, I can ask another question and then maybe catch the same objection, but I'm going to ask more specific about this area and this case.
That would
in
be
more time.
beneficial to me.
I will do that, Judge. I'm sorry, Mr. Zick, I don't mean to cut you off.
That's
but,
okay.
Are you aware of blitzes that were done during your tenure working up here in the northern region?
I was. Oh,
Just aware.
yes, I was.
And would it be fair to say that some of those cases were well past 60 days?
Objection, Judge, relevance with respect to in the northern region, not with respect to the Woodstock office, not with respect to these defendants.
Sustained. If you go particularize it to the Woodstock office, then I'll allow it.
Yes, sir. All right. Are you familiar or were you aware that there was a blitz or blitzes done in the Woodstock office during your tenure while you were working up here?
It was not during my tenure.
Okay. Are you aware of ones that were done after your tenure?
Yes.
Objection, relevance.
Well, what's her foundation for knowledge about that if she wasn't there anymore?
Yeah.
That's right, Jim. I understand.
Sustained.
Okay, that's fair enough. In your experience as being a supervisor of Andrew Polovin, are you aware of similar reports that he was supervising that look like this C sequence?
Objection, relevance.
That look like what?
The C sequence report that we're talking about here in this trial.
I'd also add form of the question.
I'm not sure I understand the question either.
Okay.
You
Well,
can rephrase and we'll see if I understand it.
Okay.
If I do, then maybe I'll let her answer it.
I'll do better.
Okay?
Right. Do you know, in your experience working with Andrew Polovin, that he was filling incomplete reports according to what you're testifying happened here?
I'm sorry, I'm not still understanding the question, I'm sorry.
Do you have a bunch of reports? Are you familiar with reports in Andrew Polovin's past
Some, sure.
that looked like the C sequence in this case?
Judge, objection, relevance, form of the question.
Well, I think it might be relevant, it's the form of it, that look like the ones in this case.
All right, I'm sorry. Did you flag reports from Andrew Polovin that didn't have the details and the records and things like that in them that were approved or unfounded in your experience with him? Do you see a pattern of that with him during the time you were his boss?
There were a number of cases that I was aware of where they were hastily closed. Yes.
Okay? And was that awareness that you have about those cases, was that done in preparation for the report that you prepared as an expert witness? Or was that from the time that it happened, back when you were actually working in DCFS as his boss?
If I understood your previous question, it was during my experience in working with him, and it was during my experience in working with him.
Okay. Did you ever bring him up on a grievance or some type of allegation of deficient work?
Mr. Polovin was disciplined for
what?
In part of the, he was also, well, he was counseled about those things, about hastily. Counseling is not considered part of discipline. It is literally a conversation that you would have about deficiencies, or it could be good or bad, you know.
So
But
counseling then would be, is that written down somewhere that he was counseled for such mistakes or?
usually it would be in just a memo form, because it's a more informal thing.
Would that be in his personnel file?
No, that's not considered part of discipline,
Okay.
no.
And how many times we're talking about?
I couldn't even begin to guess.
But you do remember that?
I know that he was, yeah.
Okay. So he showed up for work when he was supposed to, correct?
Yes, he did.
He worked longer hours than most employees?
I don't know, longer than most employees, but Mr. Polovin worked, yes.
And he was under your supervision as a supervisor for quite a long time, up until the point you made regional administrator, correct?
No, I believe during that time I was reassigned to other offices.
Well, again, let's go back.
I was in that role, but I was assigned for time for Lake County. I was assigned for a while. I had DeKalb, Sterling, Freeport. Yep. I mean, I had different geographic assignments.
That was as area administrator or regional administrator?
area administrator
Okay.
or child protection manager, whichever title.
Okay. So, would the area administrator meet with the supervisors on a weekly basis or something like that at the local offices to get debriefed or find out what's going on and keep tabs on things?
Generally, that was the expectation of the practice. And in addition to that, there would also be regional supervisors meetings.
And do you believe that Rhonda Lay would meet with the Woodstock field office, the supervisors that work there, and talked about their cases on a regular basis?
Objection, relevance.
Overruled.
You can
Answer.
You can answer.
I know that she spent quite a deal of time up in in Woodstock. I can't tell you the specifics of what she did during the days that she was up here and who she talked to, but I know she spent quite a bit of time in Woodstock.
You discussed a concept yesterday and called, in referring to a reading of a P300, and in the interpretation, there was an interpretation that you made using this principle of mindset of the department. Do you recall saying that?
No, but I'll go with you on it.
All right. So are you surprised to hear me say that, or do you understand what I'm talking about?
I think I understand what you're talking about.
So, what do you mean by the mindset of the department when it came, in this particular reference was to something that, a regulation in a P300. So how does that apply and what is it?
I don't know what specifically you're talking about. I'm
Well,
sorry.
Well, you just said that, I think I can paraphrase it.
Okay.
There was a regulation, I think it was about drafting a notes, and Ms. Lee asked questions about what the regulation said, and you had indicated that, well, that's what it says, but the mindset of the department is it needs to be more comprehensive or more detailed or better than that. More than that. It wasn't enough in the regulation, and that was the mindset of the department. Does that ring a bell?
Mindset expectation, yes.
Okay. What is that?
It means what I would mean that would have to elaborate. You'd have to have more detail if that's what you're at.
Okay. So that's mindset of the department is exclusive, in this case, at least at this point, to only that reference that I just made, correct?
If I'm understanding you.
Okay, so let me ask you this then. Other than what we just talked about,
Okay.
are there any other regulations that were met in this case that you believe weren't up to the mindset of the department just because it was followed exactly like the regulation said? It should have been better, should have been more.
That sets out the bare minimum.
But the regulation says, using your term, bare minimum, correct?
Yep, that is my turn.
You just don't agree that that's acceptable.
No, those are the bare minimum.
Right, but you don't agree that's acceptable, and you believe it should be more than that.
There's specific cases where you need more. You'd have to explore further. Some are more involved than others.
Is that concept communicated to the investigator and the supervisor that, I know it says this, but the mindset of the department is, it's got to be better than that?
Well, it just can't, it's not meant to be superficial. Again, these are the bare minimum.
Uh-huh. But are they
Utilizing
told-
clinical and investigative skills, it should be, yes, sometimes you need to go further.
Okay, and you tell them that? You tell the workers that?
Did I directly?
Well, whoever's supervising them, whoever's training them, whatever, is that something that's communicated to the workers? Or is
there-
it just your theory?
No, actually, during the time that I was there, and I can't speak to now, we went through a couple different things. An accreditation, and that when the department went accredited, it happened several times, there were expectations as part of that about the detail that notes needed to be, things like that. We're also going through what they referred to as, I think it was in line with the federal review, and we had, I can't tell you what the acronym meant, but it was called PIP. And in those, they would our quality assurance people would highlight areas that I believe it was the federal people would be looking at that we needed to do better on.
Are you saying, you're referring to the consent decree when you say federal? What do you?
No.
I'm not sure what word you're using.
The federal government made us, and again, it happened when I was there, but not, we were failing it. It was a review that we had to meet certain federal expectations, separate from the consent decree.
Okay.
All states were going through this. And as part of that, our quality assurance people were working closely with the department in line with what the federal expectations were to make sure that we were meeting that. And some of those had to do with like documentation, what was expected, what the feds and the department expected. So those were ongoing addressed through the quality assurance, through, like I said, when we were going through those reviews, be it through accreditation or this.
So when was that?
That was accreditation, I'd have to go back, I think it was every 4 years. And the federal review, when I left, was still ongoing. Yeah, I don't think it had been concluded.
So when that happened, did you then go back and amend the P300s or add to them to incorporate this language?
No, these were things that the supervisors and investigators were, more so it was probably the supervisors,
So
to
that's-
filter down, that these were the expectations that the department was.
So now there are more expectations and on top of the regulations that are put upon the decision makers, again, that would affect their ability to make decisions or.
It was really about quality. A lot of it was about quality.
All right. The first 24 to 48 hours after a hotline call are pretty much the most serious and need the most attention. Isn't that correct?
Fair to say.
And people move quickly to get out there and to deal with the situations, correct?
Right, because you're under the time frame.
Correct. And during that time, the investigator is the one who's on the street, going places, talking to people, doing everything he needs to do his job immediately after leaving the office after being assigned a particular case, right?
Right, they're the ones out in the street.
And in that time frame, 24 to 48 hours, the supervisor is in his office working, correct?
I would believe so.
Well, he's not investigating, right?
Oh, yes. He could be assisting, but he's not, if you're asking, he's not on the street,
Well,
generally.
In this case, in the case of
Okay.
the trial.
Okay.
Andrew Pollard was at his office. He sent Acosta out to take on this hotline call, correct?
I would believe, yes.
So he's not out there talking to people. He's not out there looking and seeing, correct?
Correct.
His eyes and ears, the supervisor's eyes and ears, come directly from information given to him by the investigator, correct?
That is correct.
The investigator controls whatever the supervisor hears or sees in that time frame, correct?
Yes, at least initially.
And it's essential that the supervisor takes on that information, notes it, but then trusts that the work that he has set the investigator out to do is getting done, correct?
The supervisor's role is to also ask questions. If, say, an investigator's calling Mr. Pollard in this case, if Mr. Pollard has any questions or like, that doesn't make sense, or can you clarify it, or they can talk about additional tasks at that point. Do you know what I mean?
So
It's
the
just
answer-
not absorbing the information.
So the answer to the question is yes. He has to rely on the investigator, correct?
Essentially, for the initial
And
information.
he has to trust the investigators telling him the truth and telling him what he needs to know, right?
That is true, yes.
And there's nothing wrong with that, is there?
No,
It's essential, correct?
correct. Supervisor.
Because he's not out there, right?
Yep, that's correct.
Just like the CRAP that we went through, you had gone through yesterday, which we're all here for. The CRAP is a Q&A questions asked by Andrew Polovin to Acosta in this case that Acosta gives answers to, correct?
No. What? Say that again.
The CRAP is a question that, those are questions that are given basically under the supervision of the supervisor. Acosta answers those questions, correct? Polovin does not answer the questions in the CRAP.
Correct.
He has to trust that whatever information is going on that document in that time frame is reliable and truthful, correct?
That is correct.
Unless he has no reason to disbelieve him, right?
Right. And he could challenge something or question it, but yes, he has to rely on the investigator for the
Well,
information.
If there was if the investigator had told Polovin something different, answering a question in the CRAP, that would be obvious that the information isn't right?
Say that again, I'm sorry.
If Polovin didn't have any information that came only from Acosta, there would be nothing to challenge him on, right?
Except for you would probably have a copy of the narrative of the report.
Okay, that's what I'm saying. So if there was contrary information he had, that's the only reason. But other than the preliminary report, everything that he received, Polovin receives, comes from the investigator.
True.
And the CRAP's answers are controlled by the answers given by the investigator.
Yes.
At the end, when the sit-down happens and there's a determination whether to indicate a case or unfound the case, or find the case unfounded, the controlling voice, the controlling input, the recommendation that has the most weight is from the investigator, correct?
No, it should be really equal. It should be. I mean, it's a discussion.
Okay. Does the supervisor say, we're indicating this case first, or does he say, investigator, you give me your information, give me your pitch, and what do you think? And then it moves on to the supervisor, and he considers it once a decision is given by the investigator.
No, it should be done as the discussion. The investigator should never make a recommendation unless discussing it with the supervisor, and they together agree.
Okay, right. But after the discussion, the investigator's input drives the next things that happen, correct?
You mean actual input?
After the input, after they talk about it,
Okay.
when it comes time to saying, I want to indicate or unfound the case, the investigator takes the lead in the recommendation, correct?
No, because that discussion is the discussion decide, are we going to indicate or unfound it based on the facts? So it's already, the discussion's already occurred, so the decision's ultimately already been made.
All right. Maybe you're not understanding exactly
Okay.
how I'm saying.
I'm sorry.
Who takes the lead in making the first initial, this is what I want to do. I want to unfound the case. Is that the investigator or the supervisor?
Objection has an answer.
Sustained, Mr. McQuaid, I understand the answer. I'm not
Okay.
sure where you're going with this. She said at least 4 times now that it's a discussion, 2 people discussing with each other. You keep asking the question a little bit differently, doesn't change the fact that she says it's a discussion. Move on.
All right. Are you familiar with the term triage?
In what context? I'm sorry.
We'll start with like an emergency room.
Yes.
Okay. And that's what basically, if they have multiple injuries, cases that come into the ER, they determine which ones need the most attention right away, and then they place the other ones in the queue or behind it due to the need for treatment, correct?
That is my understanding, yes.
Do investigators and supervisors triage cases?
I couldn't tell you that. I would imagine they prioritize.
Okay. Mr. Zucca, you went over the C-sequence SACWIS in ultimately determining your opinion or giving your opinion, correct?
Correct.
think that is Exhibit 24. Do you have Exhibit 24, ma'am?
I do, here.
Judge, can ask leave that she could be
Go
referred to
ahead.
Exhibit 24 during my report.
I would prefer that, actually. So, yes, whatever exhibit is going on that you wish her to refer to, let her know in advance so she can open up the page to it, and this is going to go a little bit faster.
Yes, Judge.
Okay.
Thank you.
So you have it right there,
I
ma'am?
do, I have it right here.
Okay.
Okay, all right. So on Bates 168, Ms. Ruzicka,
I have it.
okay, that is the emergency response. That's the hotline call and the narrative of the hotline call in that particular note, correct?
That is correct.
And I believe, okay, and can I ask you to refer to page 185? And please let me know what you want.
I'm there.
Okay. Page 185 reflects the supervisory consultation of Andrew Polovin with Carlos Acosta, the contact date and time being December 18th, 2018 at 9:25 a.m., correct?
Correct.
And in this note, it reflects contents of the actual hotline call, correct?
Right, what it came in for, yes.
Yes. And then, as you continue down the paragraph, let's begin referring to it. So, we see Andrew, age 5, has a large bruise to his hip area, and that the mother said it was from the dog. Correct? You see that?
I do see that.
Okay, and then, because it's kind of a run-on sentence, so I just want to get it all in.
Sure.
The reporter is questioning on how the minor actually sustained the injury, and then it says, a previous report was indicated in 13, and I imagine that's 2013, for unknown reasons, correct?
Correct.
And a report was unfounded in 2018, correct?
Correct.
Now, this is Polovin's note, correct?
It is.
Does it appear, based on your reading of this note and your experience, that Polovin included these previous reports in this note?
That he included the actual?
No, he wrote this, the
Yes, he-
previous report.
Right, this is Andy's
Okay.
note.
Okay, so that wasn't in the original hotline call. This is information that Polovin obtained and put into the note. Fair to say? Because he wrote it, so it must have been true.
Just one second. By the nature of the sequence, he knew, you would know there were prior reports.
But he specifically put years.
He did, he did.
So that was the work of Andy Polovin, correct?
This is Andy's note, yes, uh-huh.
So then it goes on to say, again with a comma, we haven't reached a period yet, contact police regarding the incident. That is a direction to the investigator, correct?
Right,
To find out previous contacts with the family, see the minors to ensure their safety. You see that?
I do see that,
Okay. Find out how the minor sustained his injury, correct?
correct,
Comma, find out how the parents provide discipline, correct?
correct,
Reprimand the parents if they use any means of corporal punishment that could have led to an injury. right?
correct, correct,
Take photos of any injuries and complete body chart, correct?
correct,
Have the parent take the minor to see a physician to treat any injuries and to complete CANTS 65A, correct?
correct,
Talk to workers from previous reports in community-based service providers, correct?
correct,
Who is the family support system, correct?
correct,
Update PSA, that would be Supervisor Polovin, correct?
correct,
With any new developments for critical decisions, and if there is a need for a safety plan, refer for services as needed, correct?
correct,
Contact collaterals who know the family, correct?
correct,
Assess the condition of the residents for any health and/or safety hazards, right?
correct,
take photos of the residents for the record.
Correct.
Yes? Have the parent make a care plan for the minors until the residence is considered to be safe and with no hazards noted, correct?
Correct.
Now, and underneath that, it says decision tree, correct?
Correct.
Is that something that the supervisor would type in, or is that generated by the computer?
No, this is Mr. Polovin.
Okay, so then there's more information he includes in there. Complete leads check, correct?
Yes.
Contact reporter, source, OPWI.
Right, that's the other person with information.
Okay.
Yes.
Notify police if appropriate.
Yes.
Follow all protocols and complete all screenings required by Procedures 300.
Correct.
Document all contacts in CRAP within 24 hours of contact, correct?
Correct.
Apprise PSA of all critical points, correct?
Correct.
Update PSA with any new developments for critical decisions.
Correct.
This is what the supervisory consultation note should look like, correct?
This is a supervisory consultation note, yes.
It's detailed?
Yeah, he's giving him the initial direction, yes.
Okay. And it's a lot of directions, correct?
Yeah,
I mean,
there's quite a few tasks in there.
okay. And that's, the mindset of the department would like that one, right? Or is there more, did he miss something?
No, a supervisor could write an initial supervision note with just what, you can break this down in supervision, because supervision is an ongoing thing with an investigator. So if Mr. Polovin had chosen to, he could have broken this note into several different steps. Go out and do this. Okay, let me know what you did. Now let's talk about these steps. So you don't have to put everything all together. It could have been done incrementally.
One more thing.
Okay,
He created this, so this note was entered at 9:25 a.m., correct?
no, that's contact time.
Contact time, oh, sorry, right. Contact time was 12/18/2018 at 9:25 a.m., correct?
Correct.
He typed the note in at 5:36 p.m. the same day, correct?
Correct, he did.
He didn't go home at 4:30, did he? He didn't go home at 5, right?
I wouldn't know that because we all had computers, but he did, this reflects he was working at 5:36
He was working
PM.
at 5:36, correct?
Correct.
Does that strike you as someone you would describe as lazy?
Oh, no.
I'm gonna ask you to stay with the C sequence.
Okay.
With me, please. But
Okay.
then I'm gonna complicate things and ask you to look at something else. So Judge, I'm gonna ask Ms. Ruzicka if she can refer to the demonstrative exhibit.
Do you have that right there, ma'am?
Yes, I do.
No, I think that's the 300.
Oh, is that,
Oh, you can use mine if you want.
oh, I'm sorry.
Judge, may I approach?
Good.
All right. Ms. Ruzicka, we'll just use this, even though it's, so I'm going to refer to page 73 of the demonstrative exhibit, please. And let me know when you get it.
Okay. Is it a contact note?
It would be, it's a contact note. It's
Yes.
People's Exhibit 24. There's a Bates of 190 on
Yep,
it.
I have it right here.
Okay. All right. So this note is in the SACWIS for the C-sequence case, drafted by Carlos Acosta, correct?
Correct.
Okay. And the contact time in this note is 12:35 a.m., correct?
That is correct.
And in this note, I ask you to go to the last sentence. And You're looking, you've seen it, right?
I know where you're talking,
All
yes.
right. So then, I'm going to read it. Worker, after consultation with supervisor, informed CLPD that DCFS would be allowing PC to lapse and children could be returned to the mother. To mother, correct?
That's what it says, yes.
Okay. Now, if we can then go to, well, we don't have to go there just yet. So let me ask you, I'm going to talk about PC, the PC in this case.
Okay.
Acosta indicates that he consulted with Polovin in regards to letting PC lapse, correct?
That's what this note reflects, yes.
That's what the note reflects. Is there any note that correlates and corroborates that particular decision in that note from Andrew Polovin?
No, this is Mr. Acosta's note.
There's no note from Polovin indicating that he consulted with Acosta and let PC lapse, correct?
That is, yes, that is my memory.
Okay, and that was at 10:35 a.m. when this contact time was entered.
The consultation, do you mean?
The initial contact time. On the note,
Uh-huh,
it says 10:35 a.m., right?
correct. That's the interview
So-
with the mom.
So at that point in time, around 10:35 a.m., Acosta lets PC lapse, correct?
Yes, somewhere in this time frame. Yes.
And that's based on the note. That's the time on the note, correct?
That is what the note reflects.
Okay. Let me ask you this question. If a supervisor allows or makes a decision to allow protective custody to lapse, does the supervisor have a required duty to inform the area administrator that we had a PC and we're letting it go?
No, I don't. At various times over the years, but I believe at this time, there was not that responsibility.
Okay. And we know from the original hotline call that PC had been taken at the time that the hotline call came in, correct?
Correct, correct.
Again, this is basically less than 2 hours that the investigator is now out on the scene, or an hour possibly, correct?
From the time of the report, you mean?
Yes.
Yes, because it was an emergency report.
And again, we're in that 24-hour time frame when everything is happening fast, and the workers need to get things settled, get in front of it, and figure out what to do, right?
That first 24 hours is critical.
But that decision to let PC lapse, that's a big one, correct?
I would say so.
And again, well, yeah, I'll ask another question. I'm going to ask you to turn on the same, yeah, on the demonstrative, page 77.
I see it.
Okay. Now this is the text message that we've referred to in this case, correct? That was
Correct.
I'm sorry. Things are better than that. This is the text message that you testified to that was from Acosta to Polovin, correct?
Correct.
And this text message was sent, it appears, from Acosta to Polovin around 11:30 a.m., correct? Or 11:35 a.m.?
I don't see a
Well,
time.
It's
but
better. Okay. Judge, may I
You may.
the exhibit? Thanks.
What do you?
An exhibit, but the actual exhibit, I think, is more clear.
What exhibit?
It's 30, is it 32?
32.
This is 30 and 35. Here it is, Judge, I can reach it.
Okay.
Can you reach it? I can read your- I think Judge may approach the witness with the exhibit.
Okay.
I'm not going to show you what's been marked People's number 32, which is in evidence. If you can take a look at that. And that would be the
Oh,
same
yeah.
thing we're looking
Yeah.
at in the demonstrative, but it's a little more clear.
This is clearer, yes.
Can you tell me the time that that text was sent to Polyvan?
11:30.
Okay. So at this point in time, PC's already have been allowed to lapse, correct?
According to Mr. Costa's note.
So, and so let's discuss this as well.
Okay.
In this text, would you describe this as a request for supervision or request for assistance?
No.
Is there anything about this text that indicate who this boy is or who this child would be or who this person is at all?
No, it just says kid.
Okay, and again, Polyvan does answer, that looks nasty, but that's what the kid says. We know that that was the response that was given by Andrew Polyvan, correct?
Correct.
Judge, just for the record, that looks nasty, but if that's what the kid says.
Okay. I agree.
Okay.
Thank you. That's what it says, right?
This copy is a little sketchy, but I do believe that's what it says.
Well, Mr. Keneally said it, that's what it was. so
Right.
we're
No,
gonna go along
I
with
believe
that
it.
right now. So there's nothing in the SACWIS, any report that refers to that text message, the texted photograph and message and the response, correct?
Are you asking me if there's a note to reflect this?
Yeah.
No, there is no note.
And it's certainly not a consultation of any sort in regards to any decisions made on this C-sequence case and the investigation of A.J. Freund, correct?
There's no decision in these words, no.
And again, Ms. Ruzicka, the investigator is only as good, the supervisor is only as good as the investigator when it comes to the information that he receives. Is that a fair statement?
That's a fair statement.
Okay. Judge, may I
This-
approach and take the exhibit back?
You may.
I wanna-
This is it.
It's a busy witness.
Do you want this one too?
I'm gonna keep that. You can close this one.
Okay.
Keep that. I'll keep the
Okay.
Okay, go ahead. Take a drink if you want to take a drink.
Okay, thank you.
All right, Ms. Ruzicka, could we go to page 111 of the demonstrative exhibit?
I'm there.
Okay, so I want to go to the highlighted paragraph that begins when law enforcement.
Okay.
Okay.
I see that.
This paragraph indicates, and I'm going to paraphrase it, that when law enforcement has an ongoing investigation, the child protection supervisor shall facilitate and participate in a joint child protection conference with law enforcement. Well, I didn't paraphrase it, I read it. So basically that indicates that there's a shall in here, right? Shall
Correct.
facilitate and participate in a joint child protection conference with law enforcement, correct?
Correct.
And then, but that does indicate that it would be when law enforcement has an ongoing investigation, right?
Correct.
In this case, the case at trial here, the C-sequence case, you knew, or you know now, that at some point that the reporter, the hotline reporter was a police officer, correct?
I do know that.
And the police officer took protective custody of the children and brought them to the Crystal Lake Police Department, correct?
Correct.
And during that time, the investigator, the DCFS investigator Acosta came to the department, correct?
To the police department, you mean?
Yes.
Yes.
And conducted an investigation, correct?
At least initiated one, yes,
Okay.
started.
All right. And you know then that he let protective custody lapse, right?
Right, it's documented.
Okay. And at no time did police engage in a parallel investigation, correct?
That I don't know, but it's not reflected in the investigation.
Okay. Well, if the police said, you know, we're going to keep going, that would be reflected in the SACWIS, correct? if the police had a parallel investigation, it should be in the SAC list that Crystal Lake PD is continuing their investigation of Joanne Cunningham, right? If that was happening.
It would, the question would have to probably be asked of the police.
Right, well, if the supervisor is going to facilitate and participate in a joint child protection conference with law enforcement, he should know that there's actually an ongoing investigation by the police, correct?
He would have to be informed of that.
In this case, the police did not conduct an ongoing investigation, did they?
It does not look as if they did.
You know that Ms. Cunningham was not charged with any crime, correct?
Well, I think she was charged with driving without a license or suspended. But.
Sure. But she wasn't charged with domestic battery, or there was nothing about the injury investigated by the police regards to that wound that he had suffered.
Right, she was not charged relative to
Okay.
that.
There's no law or rule that says if DCFS comes out to the department and initiates an investigation of an allegation of child abuse, that the police then have to stand down and defer all investigation to DCFS, correct?
No, if the police are involved in DCFS, DCFS takes the lead, but it doesn't mean that they wouldn't continue whatever their investigation is, if that's what you're asking.
And if the police decide that it's DCFS's case and not ours, that's within their province to do that, correct?
That is correct.
But there's no rule or law saying they have to do that, right?
That they have to, like, stop their investigation?
Yes.
No.
That's a choice, right?
It would be a decision made by the police.
Would it be fair? If Mr. Polovin was fully staffed with 7 investigators, it would be a fair assumption to say that they had a large amount of cases under his purview, correct? That were still open and being investigated, right?
I don't know what you mean by large.
Okay. Let's just go along with, I'll refer back to let's just say it's 70, which is within the consent decree, that he had 70 open cases at the time, which is not excessive. I'm just using this as a hypothetical.
Sure.
70 is still a lot of cases, correct?
You want in my personal?
Well, I asked the question.
Okay.
You're please answer.
Is 70 a lot? No, it's somewhat manageable.
Okay. It's manageable, right?
It's manageable, yes.
But, so, his management of ongoing cases is a big part of his job, correct?
Right, that's his job as supervisor, yeah.
But there's also other elements that go on in his workday.
Sure.
Is that true? So immediately when he gets to work, a supervisor is going to be dealing with at least 5 to 7 new cases that came in overnight, correct? New
No,
hotline calls?
no, I would not say it was 5 to 7. No.
What would you say?
Some, it depended. If it was like on a Monday and you had a lot of calls over the weekend, you might be dealing with many more. You could end up with a very quiet day and not have any. Unfortunately, there was really no way you could predict.
All right, so if it's 7 or if it's 1, it's something that has to be dealt with first thing in the morning, correct?
Yes, if it came in like overnight or after hours, or
Yes.
it's there, yes.
And there's a process of then assigning an investigator to that, sitting down with the investigator, debriefing them, and sending them out to deal with the call, right?
That's correct.
And then a supervisor would be working on closing cases, correct? That would be what he would be doing, right? He'd have cases he needs to work on getting closed with his investigators, right? He'd be meeting with, yes?
Yes,
He'd
yes.
be meeting with investigators all day, probably, talking about the cases. Those that want to be supervised and consulted, he would consult with them, correct?
He would. Usually the supervisor would structure their day so that they could manage it, yes.
And by working on pending cases, the supervisor would be making calls, possibly calling the police, calling different people to get the information that needs to complete the investigation, right?
They could be assisting an investigator, sure.
And there are times when the supervisor's on call, correct?
That's after hours, yes.
Okay, that's after hours?
Yeah.
And that is like 5 to 10 days a month you may get assigned to be on call?
Yes, but it was a voluntary thing.
Okay.
Supervisors didn't have to do it. Some chose to do it not at all, or 1 or 2 days a month because it was part of their job description. Others chose to pick up additional days and hours.
Okay. And was that overtime
They got paid cash overtime.
for the on-call time they spent?
Uh-huh.
And is that,
Excuse me, I think there was an option where they could also ask for a compensatory instead, but yes, they were
Outside of the
compensated
salary.
for it.
it was outside of the salary structure?
It was, yes.
And would you say that as a supervisor, which you were at one point in time, that there is very, very little downtime in that job on a daily basis, correct?
You'd have to make sure you build that in for yourself, but yes, you could potentially work, just work.
Better for
Yeah.
your mental health?
To take some breaks? Or
Yes.
I would say yes.
And would it be out of line with that kind of schedule, with that kind of case management, to rely on your experienced investigators to do what he told them to do?
Historically, the fact that somebody would be like an advanced investigator, as you say, or
Yes.
advanced specialist, would be under the belief that they were just that, advanced, a little ahead of, in terms of their skills, in terms of their knowledge, than somebody else that would be, for example, like brand new. You know, they're the more experienced folks, generally.
And in those
Generally.
circumstances, again, the investigator drives the information, correct?
Correct,
The investigator investigates, correct?
correct.
There's nothing in this C sequence that Andy Polovin put that was false, correct?
No, I don't believe there is.
He didn't make anything up, correct?
That's
He
correct.
didn't attempt to cover anything up, correct?
Correct.
He did not put anything that was untruthful in a note.
Not to my
correct?
knowledge.
And I believe I read somewhere that there's, you can correct me if I'm wrong, that there's a regulation or something in the P300s that indicate that you're recommended maybe, or mandatory, that you sit down with the investigator and then tell them what questions to ask during an interview with a particular witness, subject. Does that exist?
Yeah, there's something in there, or suggest, or,
Suggest?
no, I mean, like, there's, if my memory serves me, like example of questions, like things you could, you know.
And is that the kind of thing to actually, when you're not doing the investigation, to actually tell the investigator, well, here's exactly what you should be asking? Is that?
It depends on the investigator in the investigation itself. A lot of it has to do with people's skill level, the complexity of a report. So, yes, at times you would tell an investigator, you need to ask this, and this is the way I would suggest you ask it. So yes, you would. You'd almost model for them.
Judge Mayor, one moment.
You may.
Thank you. when protective custody lapses, as in this case, at 10:35 a.m., once that's done, you can't go back and undo it, correct?
That's correct. You'd have to have another incident.
Judge, that's all I have.
Okay. We're going to take a recess right now. It's 10 minutes after 3. State, do you have a sense as to how long the redirect might be?
10, 15?
Okay. All right, so it's 10 after, we'll come back at 3:20.
Do you, Your Honor, what do I do with that?
You can just leave those there.
Okay, thank you.
Okay, ma'am, you're still under oath.
I understand.
Okay, Mr. Zeke, I imagine you're exhausted after a long day, a long 2 days, so I will try to be brief. So when you, in 2018, December of 2018, you were regional manager?
Correct.
And how many offices were you overseeing?
11 field offices, and I believe it was 17 counties.
And can you approximate how many supervisors would you have been
Oh.
overseeing?
Oh,
Ballpark.
at least 50?
Okay, and how many investigators would that have included then as well?
Oh. Could be upwards of like 250.
Okay, and was it your job to oversee each of those investigations and to micromanage them?
No, and there was also area administrators in there as well.
Okay, so do you employ investigators and supervisors to investigate these cases into child abuse?
Right, that is what they're hired to do.
Do you remember being asked about how some serious cases may get more attention than others?
I remember.
Okay, now, when you say this isn't like a serious case, do you mean it's not important?
No,
What do you mean?
it's not, in terms of seriousness, at face value, there's concerns in the report, that, what I would call red flags, for lack of better. But in terms of not serious, what I would classify as a serious is unfortunately like a baby with a skull fracture, something that is really pretty horrible.
Okay, so the fact that this may not have been the most serious case DCFS handled, did that mean that AJ didn't deserve a thorough investigation?
Oh, absolutely not. It has nothing to do with it.
Did that mean that the investigators didn't have to follow the P300s?
No, it has nothing to do with
Did
it.
that mean that the investigators didn't have to work hard?
No,
Did that mean that the investigators didn't have to use common sense?
no.
Do you remember being asked about Daniel Nowicki and whether or not the information indicated that he wasn't living in the house?
I do remember being asked
Do
about
you have
that.
the C sequence up there?
I have it in the exhibits, yes.
Okay, would you mind pulling it open, Judge, with your leave? I'd ask that she be allowed to access that.
Okay?
All right. And could you go to just to page 166, the date stamp of that, please?
I do see it.
Okay, and it says subjects there?
I do see where it says
Okay,
that,
do you see where it
yes.
says Daniel Nowicki?
Correct.
Okay, and what's the residence address there?
94 Dole Avenue, Crystal
Okay,
Lake.
and what other residential addresses are listed?
There is no other residence listed.
So it seems like information would suggest from the C sequence and the handoff document that Daniel Nowicki was living at the 94 Dole Avenue.
Absolutely.
Overruled.
Whose responsibility under the P300s is it to get a lead sheet?
It's the investigator's responsibility.
Okay, so so some things, the C sequence investigation, is it fair to say it exists ultimately on a computer system?
There's some paper documents.
That you can print off?
Yeah, well, there's other things that you might, that are not on the computer. You'd actually have paper copies of.
Okay, and and when something is included in the system, does it generally give a date and a time when those things would be put in?
Right. Whoever inputs it would put the time of the contact, or whatever the document is, the time that it's being entered, and then it would show when the time it was created. The system would do that.
Okay, so in this case, it looked as though the lead sheet for Cunningham wasn't acquired until June of 2019.
That's what the date says on there.
Okay, so like that makes it worse, right?
Right.
Okay, so at no time during the C-sequence investigation did defendant Acosta get a lead sheet for Cunningham.
Objection mischaracterizes the evidence.
Response.
Well, the evidence would seem to indicate, as Mr. Zika just said, that no lead sheet was acquired until June of 2019, which would have been after the investigation was closed on June 4th of 2019.
Judge, if I may.
Yes.
The C-sequence States Exhibit 24 includes an attachment that Ms. Ruzicka testified is a lead sheet run January 4th, 2019.
Okay. So,
Okay, I'll withdraw the question, Judge.
okay,
Okay, if a lead sheet had not been acquired until June of 2019, that would make it worse.
Oh, yes.
Now, do you remember being asked about whether or not the P300s requires a child protection specialist to observe a dog?
Right, I remember being asked
those
about that.
questions? Okay, now, in addition to the quote-unquote, as you say, minimal duties under the P300s, can an investigator also use common sense?
Common sense, investigative and clinical skills, yes.
Okay, so if there's an allegation that an injury is caused by a dog, would common sense, based on your training and experience, would that indicate that someone should go and observe the dog?
The logical thing is, you say there's a dog, where's the dog? Let me see the dog.
Okay, and if the injury is alleged to have been caused by a dog, and somebody goes and observes the dog, would that have been important information as part of the
Yes.
C-sequence investigation?
Yes, especially related to what the child said about the paw.
Okay,
Yes.
and so while the P300s may not say specifically, you must observe any dog alleged to have caused an injury, would that have been something that should have been documented?
Yes, because it's alleged the dog left the injury. You'd want to see the dog and how the dog behaves.
Okay. Do you remember being asked about medical records and those having to be required to be approved by an area administrator, as well as a subpoena being returnable in 10 to 14 days?
Yes, I do remember being asked about that.
Okay, and as an area administrator, would you ever deny a subpoena request in a case like this?
Never.
Okay, and if they're returnable in 10 to 14 days, how long can an investigation stay open?
If that would be a good cause for a case to be extended. When I had said you could extend it beyond 60 days for good cause, that would be a good cause.
Okay, now do you remember being asked about the Chicago Police Department?
I do.
Okay, should the Chicago Police Report have been acquired?
It should have.
Okay, and at least it should have been requested.
Yes,
And whether or not the Chicago Police Department complied with that request, up to them, right?
correct.
Okay. In addition to the Chicago Police Report indicating that Ms. Cunningham was in Mount Sinai, could defendant Acosta have also learned that information by asking Cunningham if she had ever been previously hospitalized?
Yes, and it should have been
Okay, and
asked.
in the C-sequence investigation, based on your review, was that ever done?
No.
In addition to acquiring the Chicago Police Department report, could defendant Acosta have also asked Freund whether or not Cunningham had ever been hospitalized?
Yes.
Based on your review of the C-sequence, was that ever done?
No.
Was that ever summarized in her contact note with, when it related to Andrew Freund?
It's not even mentioned.
Now, you talked about the A sequence, and there's some discussion about what information would have been available. So with respect to the A sequence, could you tell the judge what information would have been available to defendants Acosta as well as to defendants Paul?
Minimally, the narrative, to what the case came in for, because it had had 5 years, it was expunged. The field office has maintained copies of the hard copy documentation, which would be like a police report you might have had, things that were not in the computer. The department's responsibility was to get rid of those cases after 5 years. Sometimes they weren't quite done right at the 5-year mark, so you could have gone to a file cabinet perhaps and looked to see if there had been the hard copy file, what we would refer to as a hard copy file or documents.
So what happens after 5? What happens to that document? Is it entirely purged from the system?
No, there's still information in there, it's just specifics. You can't go in and read each detail.
Can you request to?
Yes.
In your time in 2018, on or about 2018 or 2019, to your knowledge, would Merit regularly provide second opinions for DCFS investigators upon request?
Gladly.
Okay. And do you remember being asked about the type of investigation Merit handles under the P300s?
Yes, I do.
Okay, and do you remember it sort of is a list, but then it says, but not limited to?
Yes, I remember
Okay.
that.
Are DCFS investigators and supervisors expected to know what the term "but not limited to" means?
What not limited to
Are
means?
they expected just to know what that term means?
I don't know what you mean.
Strike the question. Do you remember being asked about the consent decree?
I do.
Okay. And do you have any reason to believe that in 2018, 2019, the number of cases being handled by Defendant Polovin, Defendant Acosta, or any investigators there were significantly over the consent decree?
No.
Okay. And when you were working as a supervisor, were you able to manage your caseload?
Yes, I was.
Do you remember being asked about a summary of the police reports in the B sequence?
I do.
Okay, and that's like a CAD sheet, right? Which is, it says what the call out was, it gives the officer involved. It doesn't give a narrative of what happened.
No, it's just the report itself.
Okay, well then let me ask you a question. Would you rather have information from that sheet that there was a well-being check on Ms. Cunningham, okay? Or would you rather have the police report that says that the well-being check related to an attempted suicide, and when the police arrived, they found a 10-foot rope next to her bed and in the room where she was standing? Just based on what would be more important to the investigation?
As much information as you can, which would be the police report.
Okay, now there was talk about lead sheets and like what the different dates. Do lead sheets reflect the criminal charges that are in the system at the time that the sheet is pulled?
Yes.
Okay, so despite the fact that the lead sheets for Freund and Nowicki were pulled after January 4th, 2019, had they been pulled prior to that, would they reflect the known criminal history at that time?
They would have.
Now, do you remember being asked about judgment calls?
Yes, I do.
Okay. Can people at DCFS be held accountable for horrible judgment calls because they shirked their responsibilities, made a mockery of the investigation, and were poorly informed?
Objection argumentative.
It's marginally relevant.
I'll withdraw
to
the
me.
question,
It's kind of
Judge.
my decision to make that, I guess.
Judge, I'll withdraw the question.
Okay?
Thank you. Do you remember being asked about, like, did you consider what was going on in the lives of CPS Polovin as well as Defendant Acosta at the time? Like, was that something that you considered?
Yes, I remember being
Okay.
asked.
What was the date? What was the date of this investigation? It was December 18th.
That is correct.
Did you factor in the fact that Christmas was coming and it was about to be New Year's?
Oh, yeah.
Now, you talked on direct examination. Defendant Polovin has a history of hasty work and not following the P300s.
He does.
Do you remember being asked about do you remember being asked about sort of the difference between indicated and unfounded?
I do.
Okay. So if a case is unfounded, can you then refer it to the state's attorney's office for a petition to be filed?
Even if it's unfounded, yes.
Okay. And if it's indicated, can you refer it to the state's attorney's office?
Yes.
Okay. And if it's unfounded, can you still have intact family services?
You can.
Okay. Do you remember being asked about protective action?
Yes, I do.
I mean, is the point of DCFS to protect children?
It's to ensure children's safety.
All right. And
It's the parents. I was going to say, it's the parents' job to
Okay.
protect their children.
okay, but do DCFS interventions generally work in protecting endangered children?
Give it a try.
Okay, well then why, in this case, if there was an intact family service plan, had the case been indicated, okay? Why do you think that would have saved AJ's life?
Because if nothing else, outside of, as I mentioned yesterday, the interventions that would have been there would have been eyes and ears in the home. There would have been people monitoring talking to the family, the children, the parents, individually, collectively, talking to family members, whoever's involved in that family unit, as well as the providers that would be providing services, to find out how things are doing. You'd have eyes and ears.
Okay, and do you remember talking about, how, especially with regard to PC, the whole idea is we want to meet the minimum parenting standards,
Correct.
right? Could you just take a look at People's Exhibit, part of People's Exhibit B3? Does it look like the minimal parenting standards are being met with respect to AJ based on that injury?
That boy wasn't just spanked.
I didn't quite hear that answer.
I
I
said-
didn't either, actually.
I'm sorry, pardon me. I said that boy was not just spanked.
I mean, in your opinion, with respect to immediately dangerous situation, putting a child back in the circumstances without any protective measures in an environment that caused this injury, could that be considered an immediate danger
It
to
could.
AJ?
It could, yes.
Okay, and then I'm on 123 of the demonstrative exhibit.
I'm there.
Okay, and then it talks about evidence that a child's account of facts has been influenced by others.
Yes, I see
Okay.
that.
And then Ms. Lee talked to you about child protection staff shall not use their belief that a parent or other person is influencing, coaching, or pressuring a child to make a specific statement during the course of a child's abuse or neglect investigation as a basis for indicating an allegation of child abuse. Does that mean that they can't consider it at all?
No, I mean, you need to explore it.
Okay, and if a police officer asked AJ the first time he disclosed what happened, and before AJ could answer, Cunningham told him, "Lucy the dog did that to you, right?" Could that be an example of manipulation? Could that be an example of influence?
Yes, or coaching, whatever, yes.
Do you remember being asked by Mr. McQuaid about how a supervisor, about sort of the trust between a supervisor and an investigator?
Yes, I do.
Okay. So if a investigator is letting protective custody lapse, is that a critical decision?
Right, it's a critical decision.
Okay. And if an investigator let PC lapse, and that's a decision that they have to make jointly, right?
Yes,
Okay.
should be.
So if an investigator is acting as a maverick and says, "I'm just going to let PC lapse without talking to my supervisor," should that be documented somewhere?
Yes, it should be, and it would be concerning.
Okay, and should there be some type of a response to that?
Yes, there should be.
Okay, the supervisor can't just say, "Oh, well, I just trust him."
Oh, no, no, no.
And do you remember being asked about, well, a supervisor can only make decisions based on the information that he has? Well, first of all, would Defendant Polovin have had access to all of the information in the C sequence?
Yes,
And would he have had access to all of that information anytime he wanted?
absolutely.
Okay, and Defendant Polovin was the supervisor on the A sequence, right?
He was.
Okay, and he was the supervisor on the B sequence.
He was.
Okay. And so if the information is only as good as sort of the investigator tells him, and the P300s are designed to gather information, and a supervisor doesn't make sure that the investigator follows the P300s, like, who does that supervisor have to blame?
Himself.
So do you remember being asked about whether or not, Defendant Polovin ever lied in the C sequence investigation?
I do remember.
Okay, have you ever heard the expression lie by omission?
I have.
Okay, could you turn to 118 of your demonstrative exhibits?
Oh, whoops. I see
Okay,
it.
and so this is Defendant Polovin closing out the case and writing a little summary about it, right?
Correct.
Okay. Any mention in here about Dr. Shannon's, about AJ's statements to Dr. Shannon?
No.
About, maybe mommy didn't mean to hurt me, maybe someone hit me with a belt.
No, there's no mention.
Any mention of the fact that no second opinion was received?
No.
Any mention of the fact that the injuries were not to bony prominences, but rather were in highly suspicious areas?
No.
Any mention of dog feces and a mice infestation?
No.
Okay. Any mention of mom appearing to be on drugs?
No.
Any mention of anybody's criminal history?
No, it doesn't reflect that Mr. Polovin reviewed any of the hard copy documents.
Any mention of the fact that this injury clearly is not consistent with the dog's paw?
No.
Moment, please.
You can.
Nothing further.
Ms. Lee.
No recross.
Mr. McQuaid.
You didn't factor in the caseloads that both of these defendants had at the time that the C sequence came in, and during that time until it was closed in January 4th of 2019, correct?
Didn't factor it into what?
Your decision.
Oh, no, that would be,
And you testified that you didn't consider any external factors other than what was in the reports and the C sequence report, correct?
correct.
But you considered Christmas?
I was very mindful of the date of the report, and that typically that's a time. It's right before a holiday. Yes.
Mr. Keneally asked you if, reminded you that you testified that Andrew Polovin had a history of closing reports too fast, correct?
Correct.
I recall your testimony being it was one time which you don't even remember when it happened, correct?
He had a reputation for it.
Really? Is that anywhere in his personnel file that he has a reputation for closing cases early?
Hastily. That they were not thorough. And as I mentioned before, he was counseled by me over those, and that is not part of discipline.
Okay, so you remember that, but you don't remember anything about what the caseloads were like when you were preparing this report that you gave and testified to in court, correct?
That would be correct.
And everything that Mr. Keneally asked you about, that final supervisory report, all that information's in the C sequence file, correct?
The hard copy,
Yes.
it reflects that the hard copy documentation is in there now.
So he didn't pull out Dr. Shannon's report and hid it somewhere, did he?
Mr. Polovin?
Yes.
No.
It's all in there, right?
It's in there, but I don't know if it was reviewed.
But he didn't ask you that. He said it's not in that particular note, correct?
It's not in his note.
But it's in the file.
It is in the file.
That's all.
All right, and you may step down. Thank you.
Thank you, Judge.
State, you can call your next witness.
Judge, the state would next be seeking to call Dr. Davis. However, this is one of the witnesses where Your Honor granted